are in Dallas are actually decision makers for the company. And there is no evidence that the individuals in Dallas County are decision makers for the company. Specifically, Your Honor, the courts have defined decision maker as someone who conducts the daily affairs of the company, and specifically, courts have defined daily affairs to include day-to-day decisions in running the company, the employees, and the facility. And in plaintiff's response, Your Honor, they go over a certain number of things that they attribute to the Dallas employees to define them as decision makers, but none of those actions are actually towards the daily affairs of the company. Things like providing legal services, dictating the concept of the restaurant, naming the restaurant, signing leases, paying for attorneys. Those are not the daily affairs. Those aren't things that occur day to day. They occur once a year, maybe. And you know, the concept of the restaurant and things like the name of the restaurant, that doesn't even occur once every year. Those aren't the daily affairs that are contemplated by the day, or those aren't the day-to-day decisions that are contemplated when defining the daily affairs of a decision maker. And more than that, Your Honor, in fact, the evidence tends to support the opposite, in that Murphy Sayer, the one who was deposed for the purposes of this venue issue, he stated that in terms of hiring and firing staff, in terms of inventory management, in terms of repair and maintenance, scheduling, so on, other things that general managers, or in this case, the director of operations, is in charge of between the four walls of the restaurant. We leave that up to them to ensure that those are done in a way that makes the restaurant profitable. Your Honor, that establishes that the daily affairs of the company are left to the general manager or the director of operations, which is located in Trophy Club, not Dallas, Your Honor. And so in this case, Your Honor, there is no evidence that any decision makers, as defined under this, are located in Dallas County, Your Honor. And for that reason, they have not met their burden to establish that Dallas County is the proper venue. However, Your Honor, defendant has, and simply put, defendant has established that the accident and the facts, all of the substantial facts leading up to the incident occurred in Trophy Club, Texas, which is located in Denton County. So we've established that Denton County is a proper venue of suit. For those reasons, Your Honor, defendant's motion to transfer venue should be granted.
Mr. Perdue?
Yes, Your Honor, thank you. Very briefly, Your Honor, I think it is telling that the defendants, when they chose a representative to file an affidavit on their behalf, didn't choose somebody from HG Supply and Trophy Club. They chose somebody from UNCO in Dallas. What we see in the two cases cited by defendants in this case, in their reply to our response to the motion transfer venue, they cite two cases, Deere & Co. v. Bernal, as well as Roach v. Jackson, Your Honor. And I can't share my screen with you right now, Your Honor. But
here, let me do that. I'll allow you to do that.
Okay, I appreciate it.
Go ahead.
Yes, sir. So Deere Co. versus Bernal. It states that the decision makers who conduct the daily affairs are different kinds of officials than agents or representatives, and daily affairs does not mean relatively common low-level management decisions. All of the things cited by the defendant's counsel with respect to hiring and staffing and making sure that they've got people that are working, those are all low-level management decisions. But more importantly than that, all of the decisions that are being made at HG Supply Trophy Club are being made as a result of UNCO giving them the ability to do that. UNCO can unilaterally shut down HG Supply. UNCO can unilaterally fire the general manager. UNCO chooses who the general manager is. The general manager has to go to training provided by UNCO. UNCO controls all of the HG Supply locations in the state of Texas. So the very existence of HG Supply itself is based off of the goodwill and decision-making by UNCO. We give at least 30 examples in our response where UNCO is controlling how the business is run, all of the incidences and accident reports that are filed, all of the employee payroll information, all of that stuff is required to be sent by HG Supply to UNCO. UNCO tells them to do that. They control the POS system. They control the lease agreements. They control what can be served, what type of foods, what type of alcohol. They run all the contracts. They control absolutely everything. And what discretion the general manager at HG Supply does have is granted to him by UNCO, which is in Dallas County. I think that is undisputed. More importantly, in Deere versus Bernal, the court concludes at the very end of the case, Your Honor, that we conclude that the Dallas Regional Distribution Center was not clearly subordinate to and controlled by another Deere office in Texas. That's what we have in this case, Your Honor, is that the facility, HG Supply Trophy Club, is clearly subordinate to UNCO. HG Supply has no ability to tell UNCO how to run their affairs. UNCO does have that ability, and the same thing is echoed in the Roach versus Jackson case cited by the defendants. Specifically, the court says that a principal office cannot be clearly subordinate to and controlled by another office in Texas, which is exactly what you have here with UNCO. And it goes on to say that the plaintiff's evidence shows that no other Texas office has higher level management authority than or control over the Dallas office, which is exactly what we've got in this case, Your Honor. At the end of the day,
that most recent case that you cited to, what was the holding in that case?
With respect to this case, it was the Roach v. Jackson case.
Can you show that one again, please? You went through it kind of quickly.
Yes, sir. I apologize. I'm trying to.
So they affirmed the order denying the motion to transfer venue. Okay.
Yes, sir.
That's what I was looking for. Okay.
And so based on those factors, those reasons, Your Honor, plaintiffs believe that venue is proper in Dallas County. And again, Your Honor, one thing that was not addressed in the defendant's motion, but I think is important, is that it is possible to have more than one principal office in the state of Texas. However, we believe that the Dallas office for UNCO is clearly the superior of the two locations. If the court does consider Trophy Club to be a principal office, we think it's clearly subordinate to Dallas. And Your Honor, based on that, we have nothing further.
All right, the court is going to deny the motion to transfer venue. You guys, let me see, are you guys set for trial? Make sure we have a trial setting. Yep, we have a trial setting February of 2025, so you have plenty of time to get that ready. Anything else, guys?
No, sir, Your Honor.
Oh, Your
All
Honor.
right, you have a great rest of your day, okay?
Thank you, Your Honor.
Okay, are both sides here on the at Corey Inc. versus Drage case?
Yes, Your Honor.
Plaintiffs are on this side, defendants are on that side. Okay. All righty. It's on the record on DC 23-20707 at Corey Inc. versus Schrage. Council, make your appearances.
Carrie Hoffman and Brooke Ballinger for Atcor Inc., Your Honor.
Jennifer Reinell, John Wilson, and Kayla Holderman for Drake Schrage.
Want to note that no relation between Ms. Hoffman and I.
Yeah.
She assured us of that yesterday. On the phone.
We said recused.
I don't have any attorneys of the family yet in town, though I have two kids in law school. Sawyer, if you want to come up, and you can sit up here if you'd like. All right, I've read the TRO. I don't know if there's any responsive briefing filed yet, but let's go ahead and get started.
Sure, Your Honor. We're here today on Atcor's request for a temporary restraining order based on Mr. Schrage's misappropriation of trade secret and confidential information in violation of his non-competition agreement. It's very clear and not disputed, to my knowledge, that Atcor and Cantex, Mr. Schrage's new employer, are direct competitors. They're both in the business of manufacturing electrical conduit and fittings. Mr. Schrage worked for my client, Atcor Inc., for less than a year, and I think the timeline is a good place to start. He started with Atcor on December 1st of 2022. He was hired as the plant manager for the Dallas facility, which Atcor was in the process of building out and moving from a different facility in the Dallas-Fort Worth area. He was a member of senior management, and as part of his onboarding, signed multiple agreements, as the court will see in our pleadings. He signed a relocation agreement, which is Exhibit A4. He signed a sign-on bonus, Exhibit A5, a confidentiality, proprietary rights, and restrictive covenant agreement, which is A6. He also signed conflicts of interest policies, acceptable use, and a code of business conduct. Despite signing these documents and his intent to move for this position, he was looking for new work almost immediately and resigned his employment on November 10th. At the time that he resigned his employment, he refused to tell Atcor where he was going, but did assure them he was not going to work for a competitor, which was an untruth. On November 1st, importantly, 9 days before his official resignation to Atcor, he sent 4 emails to himself, all containing confidential information. He claims in his declaration that is before the court that this was inadvertent at best. His counsel has assured me that he did not do so on purpose, but as I've brought the documents here for an in-camera review, if the court would like them, he labeled them files 1, 3, 6, and 7. There were other emails he forwarded to himself that didn't relate to Atcor in the intervening numbers, and attached countless confidential documents. He sent on November 2nd, the next day, an email to himself at his personal email address, documents regarding Atcor's profitability with its worksheets attached. And on November 17th, he sent an email to himself again at his personal Yahoo account with Dallas open items, including the plant schematics and the status of the startup at that plant, and sent himself a screenshot of his Google Drive where he had also uploaded Atcor documents. This was all a calculated decision on his part. He clearly had the right to resign his employment. He was an at-will employee, but he clearly intentionally sent these documents to himself. From his affidavit, as you can see, he testifies that he practically invented the business of injection molding and tells the court for that reason he would have no use for Atcor's documents, and yet he calculatedly sent them to himself. His experience in the industry is not the issue. I've never said, and my client has never said, he wasn't qualified for the position he held with them. If he had all this knowledge, he didn't need to forward himself Atcor's emails. When you look at his restrictive covenant agreement, it prohibits both his theft of confidential information and prohibits him from working for a competitor for 1 year post-employment. It assigns all his work product and inventions to Atcor. The agreement complies with Texas law and is supported by adequate consideration. The company promised to and did provide him confidential information in support of his restrictive covenants. And the agreement should be enforced as written. His response denies he had confidential information, but I think if you dig into his response, what's important is what he doesn't say. Again, I brought the binder with the information. If the court would like to see it in camera, it includes schematics, inventory levels and projection, costing, the entire operations dashboard for the entire facility for 2024, and the highest level of the company's confidential information. Again, he's testified he does not have possession of those documents today, but he has emailed them to his Yahoo account. And what he doesn't testify to in his affidavit is more compelling than what he does. He doesn't deny that he forwarded these documents to his personal email. He doesn't deny the email address is his personal email. He doesn't deny he uploaded documents to a Google Drive. He noticeably says he doesn't have the documents in his possession, but he doesn't say anything about custody or control. This is his personal email address. He clearly admits by omission that he took this information in November and that it is, although he says not, it is confidential. And there's no way to know what he did with it between November 1st, when he started sending documents like this to himself, and December 8th, when he engaged counsel to respond to our cease and desist letter. Given this clear theft of confidential information, we're asking the court to enter a TRO prohibiting him from using and requiring him to return all confidential information and enforcing the covenant not to compete, that he cannot continue to work for Cantex while we litigate and resolve this matter. We're asking this court for that relief.
Response?
Your Honor, numerous responses. As you obviously didn't see yet our response with his
I
affidavit.
just glanced through.
Okay, good. Yeah. He has confirmed he has no documents in his possession.
How do you, they said that he emailed a bunch of documents to his Yahoo account, so I guess I don't see how that could be if that's the case.
Your Honor, my understanding is for whatever the reason was that he did it or accidentally or whatever, he no longer has them. He can't return them. He doesn't have them. He can't use them because he doesn't have them. He no longer has them in his possession, custody, or control. He didn't use legal language, possession, custody, control. He doesn't have them. And we spoke yesterday about agreeing to even a permanent injunction that stating that he doesn't have them, that he wouldn't use them, that he didn't disclose them to Cantex. He didn't disclose them to anyone. He's not disclosed any confidential information. And we tried to explain to her that this isn't a TRO situation.
Had some very, very extensive trials and hearings on matters almost identical to this, whereas people leave their company and then email documents. In fact, one of the 2 times I had to put someone in jail in the last 17 years was when an individual did that. They claimed they didn't, and then they did. Anyway, and so what we usually do in this situation is it's kind of hard to prove a negative, and so usually we have a forensic examination done of the computer and the email of the former employee to see kind of what happened to it, because he emailed it just saying like, I don't have it.
And Judge, yes, I agree with you. We've agreed to some limited forensic discovery. If you look at the discovery request that plaintiff's counsel submitted, they asked for every device in his possession at literally any phone, any computer, any laptop, any desktop, any thumb drives, everything literally that he would have, and without any limitations on keywords or anything. So we've specifically told plaintiff's counsel that we would agree to some limited forensic examination of his email account. The only thing that they've alleged is that he's emailed them to this one email account, and with some kind of limited keywords for searching and for exclusion, because they've also asked for his healthcare information and his taxes, and none of that has anything to do with anything in this case.
Your Honor, if I might respond
So-
briefly, part of this issue is that we're here today because defendant's counsel implied to me multiple times yesterday that they wanted to try and resolve this issue. I was emailing them until 11 p.m. last night when they went dead silent on me on these issues. We have agreed to try and work through the forensic review. Keyword searches couldn't be agreed to in the extraordinary time frame we had to get that done. Agreed that we need to be able to have information. What they've told me is you should take my client's word for it. If he says he doesn't have it, but he does have it, he'll go to jail. That's not how I can rely on. My client already knows he sent this. This is the stack of information I know of that he sent to his personal email. I don't know how, and it's double-sided copies.
It sounds like she's agreed to.
At no point did she actually reach an agreement with me. Every time we came close to an agreement, Your Honor, what she did was change the terms. We never came to an agreement. And again, mine was the last communication last night.
Your Honor, I had to go to sleep because I had to get up at 4 o'clock.
As did I, Your Honor.
So I apologize for going dark on you
didn't
at 11
respond this
o'clock at
morning
night.
either.
So basically, Your Honor, we've agreed to even a permanent injunction on using, disclosing, possessing any such information. So, you know,
That's good. That's a start.
there's no, so
They
they,
just need to figure out the forensic examination.
yes. So they wanted the findings that
Is your client here?
my client is not here. He's traveling actually on business. He's in another state.
Okay. I have a speech I like to give to people in the situation. Like, did he sign on the Zoom or?
I don't know. He's in Missouri, so it's on his.
I'm
it's
sure
his
they have
affidavit.
Zoom in Missouri.
Judge, you want us to step out and try to contact him?
Yeah, not just one of you needs to go. You have 3 attorneys here. So,
Sure.
Uh,
You wanna go?
all right, see if you can get them on the Zoom. The Zoom link, ma'am, the Zoom link is on our court
website.
webpage as well, but we've also sent it to you, so. But it's the standard one on our court website. Thank you.
And so, Your Honor, my point about the forensic review is they wouldn't tell me what devices he does have. How can I possibly narrow it down when I don't know if he has 7 cell phones and 12 iPads and 3 computers? Not saying he does. but I can't tell them I'm limiting it to some device when I don't know what devices they have. They want me to agree in a vacuum to things I can't possibly know the answers to. I was willing to most of yesterday attempt to agree to these issues. But every time we came close to an agreement, the rules of the road changed.
So I agree, there needs to be some type of parameters to this. The way we've done this in the past is usually there'll be a deposition taken of the employee to talk about his different devices. My understanding is that a forensic examination should be able to tell you where the information was downloaded.
Agreed, Your Honor.
And so,
Your Honor, they've only alleged that he sent it to one email account. So that's what we would propose. I'm sorry?
You can have an email account on multiple different devices.
Correct.
They need to be able to, what they need to figure out is, did he download this information after he emailed it to himself? And then what devices were they in, and was it printed off, and was it forwarded? I mean, there's quite a bit to this. It's
Sure.
not a simple, oh, you can look at my phone, oh, look at, because it's not how Yahoo or Google.
Sure, exactly.
And he could have forwarded it from his Yahoo account that I can't see to any number of email accounts.
Right, exactly. That's
Is
why
my
you need to be able
point.
to do
You
it
can
by
tell me
email.
it's one email address, but I can't rely on someone who's essentially misappropriated and stolen
No,
confidential information.
I agree, trust but verify, kind of how you do this, so, how do you want to handle? What are y'all doing here, guys?
Your Honor, we just wanted to give you an update. We have a couple of questions.
Okay,
I mean, I would like to I need to take Mr. Schrage's deposition or send him interrogatories that answer the questions that he responds to quickly, and then have a forensic examiner examine the devices that are involved. Again, I don't know how many devices could be involved, because how would I know what Mr. Schrage's electronic life looks like?
Yeah.
And I've not been provided that information.
And nor have we been provided the documents to assess confidentiality on
I
any level.
offered multiple times to get on a Teams phone call and share them
And
via
I believe that was
stream.
at 7:30 last night. So she
That's
offered
the
to screen share
first time you asked me.
every page of documents in this binder.
The first time you asked me to see them was
doesn't matter.
7:30
This
last
is
We
night.
asked, we asked to be handled in AEO.
This
So-
is happening very quickly, I get it. I'm fussing with either of you. Let's try to, what we want to do is try to solve this problem. It sounds, the good news is, at least seems to be good news, is that Mr. Schrage is not trying to fight this issue. He's trying to cooperate. And so you just need to understand that by him doing this, he's kind of left his electronic life kind of open to inspection, because we need to figure out where these documents are, where they've been sent, all that kind of stuff. So it's going to be hard for her to know exactly what's being said. So
we're not opposed to a limited deposition for that purpose, Your Honor, and we've agreed that as long as they bear the cost of the forensic analysis, you know, that he's stated under penalty of perjury, he doesn't have it. So, you know, they're welcome to explore that, you know, and keyword searching. I've done forensics in a lot of different cases for inclusion and exclusion, because obviously the healthcare, the taxes, personal things, there's all kinds of things that are completely irrelevant to the analysis. Has to be within a certain date range. Obviously, there's some known date ranges here. He worked for them for 11 months, I believe, out of his 40-year career. So it's, it would be a fairly narrow time frame. And then in my experience, the independent third party would come up with collated a set of documents or emails or whatever the case may be. And then those would go to counsel AEO, and then we address it from there.
AEO.
Attorney's eyes only, sorry. Yeah, and we haven't.
Why do people keep doing those? Like, anyway, I see that a lot with employers these days. They come up with little acronyms. It's like AEO.
Sorry, we use it all the time in the patent realm, so.
Okay, all right, that's that.
But I have a draft protective order actually that I'll send to Ms. Hoffman this morning. And it should be fairly non-controversial.
So initially, we are going to grant a TRO to keep them from doing all of that stuff. It'd be great if we could get on, so kind of talk to them about it. So that, and then we need to come up with I guess the other step is, do you want to take a deposition? You want to take interrogatories? What do you want to do?
A deposition will go faster than answering interrogatories.
Do a deposition. limited to the issues in the injunction, so not, it's not a full-fledged deposition.
Understood.
Usually I do about 2 hours. You think that'll be enough time?
Yes, Your Honor, I do.
How quickly, I know it's the holidays, so how quickly,
I can do it on Monday. I can do it.
We'll have to find out. We'll see what
Honestly, I
he's,
don't know what his schedule is, so.
and Your Honor, just to clarify, we need him to be able to continue to work. So we just want to be sure that,
issue.
okay, we just need to be sure that you're not granting a TRO to stop him from working right now.
That's the second issue.
Okay.
So let's talk about that. So what's your argument on?
My argument
I have up, page 79 of the verified petition, which I think is the post-employment, confidentially, post-employment covenant, not.
My argument is that the restrictive covenant agreement is enforceable. He was given confidential information. He stole confidential information. And the only way to ensure that my client is protected while we resolve the issue of what he's done with it is that he not be permitted to work for its biggest competitor. Again, it's for a temporary restraining order. It's not. It's paragraph B on page 79, Your Honor, that he can't for a period of 12 months, regardless of the reason for separation, compete. And he is, no, undoubtedly working for their largest competitor in their operations. I'm not saying the scope of his job, I'm sure you'll hear from opposing counsel, is a larger scope than what he had.
And what did he say?
Car right here, want people from their car.
Needs to get on the Zoom. That was his decision not to be here for the hearing. So this is going to affect his ability to work. So you should take this a little more seriously.
And Your Honor, I would just mention that plaintiff's pleading really only moved for the TRO on the basis that the threat of the confidentiality of the documents and the potential disclosure of those was the threat that would warrant a TRO. And not enforcement of the covenant.
That's not true, Your Honor. We asked for enforcement of the covenant because of his breach of the confidentiality agreement. He is in direct violation of his restrictive covenant, and he did steal our confidential information.
I don't see that in your pleading on the application for the TRO, and we did not get a proposed order on that. And I don't think you filed one. I don't believe it was filed. Do you have a file mark copy?
Standing here, no, I do not.
What is the issue exactly?
I don't believe they pled, Your Honor, in the application. In the larger part of the case, they pled breach of contract based on the non-compete. But for TRO purposes, the only thing they argued was that due to the confidentiality issues, that was the real threat of irreparable harm, not the fact that he's actually working for a competitor.
Yeah, and paragraph 7 of on page 3, we clearly asked for that relief. We asked for it in count 4 of our pleading.
Yep.
Again, paragraph
Your Honor,
99.
paragraph 7 says, because some of the most confidential and sensitive documents, it's all based on the confidentiality of the documents, not based on the non-compete, Your Honor.
Again, that's not true. In count 4 of our application, we talk about our irreparable harm because of his damage to our industry. His continuing employment at Accor's direct competitor is part of our requested relief, in addition to using and not using our confidential information.
And it's all based on trade secret and confidential information. So it definitely was not clear from their pleading for the TRO that they were seeking to force the non-compete.
That's untrue, Your Honor. We've had multiple conversations about it. They were fully aware of it, in addition to what's in our pleadings.
No.
Okay. So let's look at the non-compete. It says for a period of 12 months, that's kind of standard. He shall not engage in any of the following activities: own, manage, operate, control, provide services to, be employed by, or connect in any manner with any person or entity engaged in any business that is located in a region with respect to which the employee had substantial responsibilities. So where is he working right now?
He was working for us in Dallas. My understanding is his position is in Fort Worth, which they claim is an entirely separate area. The DFW Metroplex is a well-known.
Is the term region defined in the contract at all?
No,
It's
Your Honor.
not, Your Honor.
No,
That's
Your Honor.
part of our issue with the breadth of it, And he's not just working in Fort Worth, he's working in other states. He's actually in Missouri right now, working. And there's other places as well.
Again, from his affidavit, he works and oversees the plant in Fort Worth and Mineral Wells. He obviously works within the DFW region. But the phrase region is not defined.
Your Honor, may I add a little bit to that? Basically, the plant in Dallas is a startup plant. Only one part of it's operational, the injection mold portion. So what he was working for Radcor was a startup. What he's working now is a series of already existing plants that are operational, which are mostly not competitive, except into the injection molding space. So it's instead of being a plant manager as he was, he's actually an area supervisor for 5 different existing plants. And Cantex has been around for almost 50 to 60 years. Adcor has been around since 2011. So it's a very mature company that he's working for. It's a better job opportunity.
So why did he have to steal our confidential information to go take the job at Cantex, Your Honor? And the answer
Our
is,
whole argument is based on the confidentiality.
Oh, and we want to trust and verify that it is confidential information. That's why we need the attorney eyes only review of it. You got to trust but verify them.
Yeah, I mean, you should be able to, they should be able to see that he actually, but I don't think it doesn't sound like there's any dispute that he forwarded these documents, right?
he doesn't deny it in his affidavit that's before the court.
But we haven't seen them. Because he doesn't have them. So
Just
We-
because
we
he hasn't
asked her,
opened
but
his
He
Yahoo
keeps,
email
he keeps
account.
signing on and then it drops. So so region is not defined and competitive with the line of business or business of the company in which employee was employed with during the employee's employment, including any prospective business to be developed or acquired that was proposed the date of termination, or any other business of the company with respect to which the employee had substantial exposure during employment.
So, Your Honor, his position at Candex involves injection molding. His position at Atcor involved overseeing injection molding. He's an operations person overseeing injection molding. If you look at their websites, the companies are direct competitors. It doesn't matter who was in business longer, they're clearly direct competitors. The facility in Dallas does injection molding. The facilities he oversees oversee and produce injection molding.
and that's something.
So what is the nature of his new job? He oversees you were going kind of fast
He's
there.
an area supervisor.
He oversees numerous plants in
Right.
numerous states.
That's why he's
basically.
flying out of state.
Right.
He's going state to
But
state.
one of them's in Fort Worth and the other one's.
Mineral Wells, Missouri, there's other places as well. It's in his declaration.
Well, Missouri's not in his declaration. Ohio, Arizona, and Florida are in.
Okay, well, he's
Okay.
currently in Missouri. on work,
Understood.
but Yes, that's what we've been told.
And again, injection molding, Your Honor, that's very old technology. He's written a book about it. It's in the affidavit. Those are skills he already had before he even arrived. They didn't teach him anything. He taught them.
Never argued whether he had the experience for the position we hired him for, Your Honor. I don't know why we're rehashing those grounds. If he invented all of it, he didn't need to take our confidential information.
I get it.
I'm back to the
I
same.
get it.
place.
I get it. So let's kind of figure out how we're going to deal with this issue. It concerns me. He didn't take this seriously enough that he felt like he could take a few minutes to do a Zoom. This court bends over backwards to try to accommodate people. A lot of courts in the state now are requiring you to fly out to, giving hypothetical county in the middle of nowhere, require you to go all the way there. I have a Zoom up. All he has to do to sign on the Zoom, if he feels that this isn't important enough to him that he couldn't take a few minutes to sign on to Zoom, that concerns me because right now, and it appears that he's stolen confidential information. He's filed an affidavit, and he's not taking it seriously, in my opinion. But
I just got a text from my assistant that he called the office and he can't hear anything on the audio. That's what I
Yeah,
literally
could you
just
give
saw.
us 5 minutes to try to get it situated, Judge?
I have other hearings I got to do, so I'm just saying that he needs to take this seriously. He's not
He
taking it
does,
seriously.
he does, Your Honor.
Okay. He's lucky he's not in one of these other counties that would require him to be here in person. I do everything possible to try to accommodate people.
I appreciate that.
And trying again. That he couldn't spend a few minutes of wherever he is in Missouri to be at his hotel room and just take care of this. It's not a good start. I'll just say that. So I'm going to grant the temporary restraining order. I'm going to, go ahead
There
and.
he is, Your Honor.
Right, there he is. Well, Mr. Drake, I'm glad you could join us. We're gonna grant the temporary, we're gonna grant the temporary restraining order. We're going to, on the first part about confidential information, we're going to, grant that in its entirety. For the job position, I think this is a little bit of the plaintiff's own making it, that they didn't define what region means. I don't know. I think at this point, there probably needs to be discovery on that topic, if that was ever discussed between him and his employer, what that region means. Usually there's some kind of definition in the contract, especially one of this length. So at this point, I'm going to prevent him from doing any type of work in Fort Worth or Dallas or anything in the Metroplex. If he needs to supervise these other areas of the country, that's fine. But he's not allowed to work in Fort Worth. I'm going to allow, I'd strongly encourage him to take this a little more seriously and to show up to hearings when they're scheduled, especially since they're dealing with his work.
Yes, Your
I'm going to
Honor.
allow discovery to occur in the case. I'm going to allow both sides to take a deposition of up to 2 hours in length on the issue of the temporary injunction. From your standpoint, I would encourage you to try to do discovery on the issue of what region means. Ever intended to cover, if there's any type of emails, that kind of stuff, that is a big issue to me. What does region mean? It should be defined. So if there's any emails that discuss that or any type of discussions, I want to know about that. I'm going to allow a forensic examination. I don't want to just shoot from the hip on that. And so I'd encourage you to try to work that out. If you can't, then we'll have another hearing on that.
We will, Your Honor.
What other expedited discovery would you like before we have the temporary injunction hearing?
Yeah, we filed a motion for expedited discovery yesterday. I don't believe it's been accepted by the court, at least when we walked in the courtroom. We also asked for requests for
Production.
interrogatories.
No, we
and
didn't.
request
For
for,
production and request for admissions, Your Honor. I'm
Okay.
happy to, again, attempt to make these issues resolved and settle them with
I
opposing
want to get them
counsel.
ruled on. So how
Okay.
many did you request?
15 requests for production and 10 requests for
That's way
admissions.
more than I usually allow. Did you agree to that?
No, we
Oh.
didn't, Your Honor. We said we would agree to like maybe 5 of each. I mean, And
That's
what-
more in line with what it is.
they get a deposition, then that should,
A deposition, 5 requests for admissions, 5 requests for production. I don't want to see 37 different subparts. It needs to be narrowly tailored to
Understood,
the
Your Honor.
issues here. Those need to be answered within 7 business days of being sent. So we can set this for hearing on January 29th. Well, I shouldn't say that. We're going to set this for hearing on January 29th. I apologize, that's during the holiday season.
January,
December?
December
Sorry,
29th.
December 29th, I apologize, December 29th. Anybody can appear by Zoom. I don't want to mess with people's vacation, but that's the only time in the next 2 weeks that I see this being able to be scheduled
And did you say a time, Your Honor? I apologize.
at, we'll say 9:30 again. And if you guys want to extend that, I highly encourage you to do that. We're also going to try to set up a mediation. So who do you want to mediate with?
Your Honor, we have used Ken Rubenstein in the past and, I think he really, delves into the facts of the case and is fair to both sides.
I have no argument with Mr. Rubenstein.
Let's do it. It's a great mediator.
Sure.
All right, so Ken Rubenstein is the mediator. What else do we need to discuss?
Your Honor, one other clarification, just making sure that plaintiff is required to quickly enter into some sort of TR or not a TRO protective order, so we can actually get a copy of the materials AEO attorney's eyes on. Because we really need that to understand what's occurring.
I was told they were going to send me a proposed protective order. I haven't seen it.
But I understand, I just don't want to delay,
No
have to come
argument.
back and fight for that information.
So there's going to be a protective order. You guys need to agree on the terms. If you don't, so the backstop to this is if you can't work out the forensic issues or the protective order, we'll have a hearing on Monday. Gary, can you grab Rhonda for me at 3:30 on Zoom? If you need it, just let us know if you need it. If you don't need it, just tell us so we can cancel you. only is if you can't work out the protective order and you can't work out the terms of the forensic examination.
And then the only other thing, Your Honor, I think we need is what bond you want us posting for the TRO.
Your Honor, if they're restricting his ability to work and, yeah, that needs to be more than $100 bond.
I agree.
That's,
Yeah.
that needs to be something significant.
Well, he's not restricted from working, he's restricted from
Working
working
in-
Fort Worth
in-
land.
Right,
I
so
need-
that's part of his current job.
He's still getting paid.
I need to ask one clarification, Judge, if I may. So when you say he can't work in Fort Worth, can he office in Fort Worth, just not support the Fort Worth plant? Because he's supporting multiple areas from an office in Fort Worth. So can he, I'm trying to
I don't know.
conceive.
What are your thoughts?
I mean, he can work from home, Your Honor. I don't know why he has to be in the office. Most people work.
I
from
think
home.
it's too it's
It's
too
too
risky
risky.
to have him in the plan. So, Mr. Drake, are you there? Can you hear me?
Yes, I can hear you.
I just want to make sure you understand that we have just entered a TRO. In this case, your attorneys can talk about it. A part of the TRO is that you are not allowed to work out of the Fort Worth plant. If you are caught in the next doing that, I just want to make sure your attorneys will probably talk to you about the penalty. But the penalty is up to a $500 fine and up to 6 months in jail. So trust me, you do not want to spend time loose there at jail if you haven't before. Not a nice place. So from here on out, I'd say he could go to the office for 1 hour to get his stuff and remove it out of the Fort Worth office. And other than that, you should not be in the Fort Worth office until further order of this court. Do you understand that, sir?
Okay, yeah, understand that.
And Your Honor, what's, again, I'm trying to parse it a little bit. You mean the physical plant or the office? Because Kentix has offices versus plant.
Are they both in Fort Worth?
There,
Why, we probably need to ask the client to confirm whether where he actually offices. I think he's in an office, not a plant.
He's not allowed to go into any Cantex office plant anywhere else in
Fort
Fort
Worth.
Worth.
Okay.
Except for that 1
So to
hour.
make sure it's clear.
Any type of, he cannot be there. At this point, we don't know what region meant, so.
Okay.
He's not allowed to be in there. He can go supervise in other areas. If he gets caught doing that, and they're probably gonna be following you, Mr. Schrager, so I would, Schrag. So I would be extremely careful about that. I've had to put people in jail before for this. I don't want to do that to you, so make sure you follow the order, okay?
Understand.
Anything else, guys?
What the bond, Your Honor?
For only 2 weeks, how much does he make a week?
I believe his salary is about $190,000. So whatever.
So
We can ask him point blank.
can ask him
Wanna
what
ask
she
him.
makes a week.
Mr. Schrag, what is your salary?
Yeah, that what they said is right.
No, I don't want him to say it. It's
Okay.
on YouTube.
I'm in the car with a bunch of people I work with, so I.
Oh,
Don't
yeah,
worry
okay,
about it.
so let's not.
Don't say it. I'm gonna set it at $5,000. The bond's
Thank you,
$5,000.
Your Honor.
It may be higher for the temporary injunction.
Wrong.
All right, anything else, guys? So
No.
you need to give me an order on this. Let
Yes,
me
Your Honor.
Explain that you need to put down the order on all of these issues. One omnibus order needs to be at the beginning, needs to say that it was heard on December 15th, 2023. You need to share a copy, and I apologize. You've been in my court before now, I can't remember.
Rhinell, Jennifer Rhinell.
Miss
Yes.
Rhinell, you've been in my court before, y'all did a good job. You need to make sure you share it with Miss Rhinell, that you, I'd like you to sign off as the form. If you can, then we'll also discuss that on Monday at 3:30. If we can't get agreement, but please do. I think my orders are fairly clear. Anything else, guys?
Not at this time, Your Honor.
Thank you. You have a great rest of your day.
Thank you, Your Honor.